Good evening. My name is Andy Horwitz. I'm a professor of law at Rhode Island University School of Law. I appear tonight in my individual capacity as a citizen of Rhode Island. I rise in profound opposition to this particular bill. I think it is an extraordinarily poor piece of social policy and an extraordinarily poor response to an issue that has generated some public concern. First, the bill is entirely unnecessary. Representative Hull seemed to be suggesting that all he was looking to do was criminalize the behavior of intentionally or recklessly being on a street and obstructing traffic. That is already a crime here in the state of Rhode Island. In fact, there were 5 people arrested and charged. I happen to represent one of them out of the protests that took place on Route 95. So there is absolutely no necessity to amend Rhode Island law in order to criminalize the behavior that the folks are concerned about. I would suggest that this is an absolutely wrong-headed response to a serious social concern. The protesters were out on that street here in Route 95 to address a very serious problem. For the legislature to respond to that problem, the problem of racism, the problem of racial injustice, the problem of police brutality, by deciding to pass legislation that stops protest, 100% the wrong message. 100% wrong message. With all due respect to Representative Hull, I have to correct him on a couple of things that he said. First, his history with respect to the civil rights movement and with respect to Dr. Martin Luther King is simply incorrect. That movement engaged in an extraordinary amount of civil disobedience, violated the law regularly and intentionally. That was at the heart of the civil rights movement. The other thing Representative Hull said repeatedly was that his design, his idea, was to stop people who intentionally stop traffic. That's not what the bill says. The bill talks about people who recklessly stop traffic, which is very different. As a person who teaches criminal law to law students, the word intentional and the word reckless have nothing to do with one another, and we should use them advisedly when we pass criminal statutes. Overcriminalization is very expensive. It does incredible damage to a variety of members of our community, and when we start overcriminalizing to the point where we're putting people in jail, we're spending extraordinary resources at a time when the state can least afford those resources. This bill involves mandatory minimum sentencing. Mandatory minimum sentencing across this nation has been disastrous public policy. Outrageously expensive, filling our prisons unnecessarily. The notion, I think, when folks pass mandatory minimum statutes is that we're eliminating discretion and we're forcing people into jail after this conduct that we dislike. That's not, in fact, what mandatory minimum sentences really do. What mandatory minimum sentences really do is take discretion entirely away from the judiciary, from the judges who we have appointed because we believe they're capable of exercising that discretion, and put that discretion in the hands of the prosecutor. So the prosecutor gets to decide whether to charge this subsection that requires a mandatory minimum or not. That's where the discretion is exercised, and history tells us that that discretion is likely to be exercised in a discriminatory fashion, discriminatorily based on race and discriminatorily based on social class or social status. The bill before you has an extraordinarily sweeping and I assume unintended breadth when it criminalizes somebody who recklessly winds up on the street and in some way delays or interferes with traffic. That would certainly include the firefighters that we've all seen with their boots asking for money for their social causes. It would include children who we've all seen on the roadways trying to raise money for the Boy Scouts, Girl Scouts, Little League, what have you. It would certainly include, and again I hope and assume this is not intended, panhandlers who are on the streets exercising a constitutional right to panhandle. Should they be in the street blocking traffic? No, of course not. That's why we already have a statute that criminalizes that. Jaywalkers could be found responsible under this statute. And a jaywalker would be as subject as everyone else to the mandatory minimum jail sentence involved in this bill. The last thing I'll say is the one particularly striking provision of this bill has to do with if there is a death as a result of what arguably could be reckless behavior that stops traffic on the highway. Recklessness that results in death, we know as manslaughter. We have that statute already. And that statute, manslaughter, which covers a whole host of outrageous and appalling behavior that falls into the category of recklessness, does not have a mandatory minimum sentence here in Rhode Island. This kind of recklessness, stumbling into the street because you're drunk, and then blocking traffic and there's a death somehow that results, would carry a 5-year mandatory minimum. It just makes no sense at all. We have statutes on the book to deal with all of the issues that are in front of this committee. I would urge this committee to defeat this bill.
Thank you, Professor. A number of good points there. Any questions for Professor Horwitz? Thank you. Representative Jones.
Professor Horwitz, or perhaps it should be just Mr. Horwitz, since you said you're testifying on your own behalf.
I am.
You mentioned that the 5 people arrested in the protest on Route 95 a few months ago can already be charged. What is the charge there, and what's the potential punishment?
So they all stand charged. Well, one case has been resolved. They all stood charged with disorderly conduct, which is a misdemeanor, which apparently is satisfactory to Representative Hull, and they face a maximum sentence of up to 6 months, excuse me, in jail. That's the provision that's on our books today.
What was the disposition of the
The one case that was resolved, I believe, was resolved with what's called a filing, which meant the person acknowledged criminal responsibility. The case was put over for a year, conditions to keep the peace and be of good behavior, and at the end of the year, presumably the case is dismissed in its pleasure.
Thank you. Any further questions?
Thank you.
Professor, would you mind coming back up?
I'd be happy to.
Thank you. Representative Bell?
I could see you shaking your head.
I'm afraid so. I'm not very good at hiding my body.
Would you like to comment on the statements about
I would.
being allowed as requirement for disorderly conduct?
Thank you, I would. Disorderly conduct, I agree with what was said, is an incredibly broad and sweeping statute, in fact, sometimes shockingly so. But what it does is it breaks different kinds of behavior into different subsections. So there is a subsection that requires somebody to make noise and create a public disturbance. That's not the subsection under which any of these 5 were charged. The subsection under which these 5 were charged says simply this: a person commits disorderly conduct if he or she intentionally, knowingly, or recklessly, alone or with others, obstructs a highway, street, sidewalk, etc., to which the public or a substantial group of the public has access, or any other place ordinarily used for the passage of persons, vehicles, or conveyances. Period. They were charged under that subsection, which only requires that a person intentionally, knowingly, or recklessly obstructs a highway. Period. That is the current state of the law.
Thank you. Vice Chair Costa?
Thank you, sir. I just
Sure.
was talking to Chairman KEABLE. A question for you. If you have, let's say, 45 people blocking I-95 straight across, there's an ambulance coming through, they can't get through, the person inside that ambulance dies of a heart attack. Do any of them people get charged with murder, or how does that work?
What you would need, well, murder would be a stretch.
Well,
Manslaughter would not be. Manslaughter would not be, which is a different kind of homicide.
But how do they determine which person would they all get charged with manslaughter?
What you would need to do is establish proximate cause, right? There needs to be a proven causal relationship between the person's behavior, which has to be at least reckless but could be intentional, a causal relationship between that behavior and the death. The bill before you would require the same proof of causation. So really, the bill before you would not change our current law with respect to manslaughter.
And I understand that, but who would get, you can't answer like who would get charged?
It would be a challenge as a prosecutor to prove that any one individual alone was a proximate cause of death. It would be a challenge. It would be a challenge under this statute, and it would be a challenge under the present law.
Thank you, sir. I appreciate that. Thank you.
Sure.
Professor, there's a constitutional right to interstate travel, correct?
Yeah.
And that was decided by the Supreme Court in the context of civil rights cases, is that correct?
I'm less sure of that, but I think it's correct.
And you would agree that we have a constitutional right to abortion in Maryland?
Yes, as things stand now, yes.
Okay, thank you. Any other questions? Representative Almeida.
Thank you. Professor, just to feed a little bit on Representative COSTA. Did you answer the question? Would they all get, would everybody get charged at some point?
Well,
or would
charged and convicted are two different things.
I'll take charge, I'll take charge.
Could they all be charged? Sure, absolutely. Right? Whether you could prove causation. But again, there's nothing in this bill that changes that analysis at all. There would be the same causal relationship that's required under this bill.
So, Professor, I certainly don't want to take Vice Chairman Costa's words for her mouth, but I think what her point is exactly the point that you're making, that it would be very difficult to charge someone, and I completely agree with the legal analysis. It's almost impossible to prove that as a case.
Right.
And her point is that that is so potentially dangerous, the blocking of the ambulance hypothetical, that maybe it should be a felony.
Well, my personal response to that is, I think we've chosen one form of behavior that we, I guess if I can speak collectively, disapprove of, which is sitting out on a highway and intentionally blocking the roadway. And you're now talking about a statute that would cover all sorts of behavior. The firefighter with his boot on the road could equally probably, in fact, based on my personal experience, more probably cause the delay of an ambulance or cause somebody who's having a heart attack not to be able to access medical attention. Any of the various ways in which people do foolish, stupid things that delay us all in our daily travel, under this bill, if they had a causal relationship to somebody's death, would not only create a felony, would create a felony with a mandatory minimum sentence of 5 years in prison. We don't apply that mandatory minimum sentence to almost any conduct in this state, thank goodness. But to decide that this is the conduct, recklessness, that has a fortuitous and tragic outcome, should cause mandatory minimum 5 years in jail, to me is just so far beyond the pale I can't fathom.
And I don't mean to suggest that I think otherwise. I'm just enjoying my flashback to law school. Thank you. Any further questions?
I have a question,
Yes,
Chairman. I would like to flash back to law school briefly as well. If this was made a felony, could a felony murder charge apply under Rep. Costa's scenario?
Excellent question.
That is an excellent question. I think the answer would be yes. I'd like to give it more thought before I gave what feels like a definitive answer, but I think the answer is yes.
Thank you.
Any further questions? Thank you.